outgoing President Uhuru Muigai Kenyatta there. Now, the Supreme Court has unanimously upheld the election of William Ruto as the president-elect in the August 9th presidential election. The 7-judge bench dismissed the consolidated presidential election petition by the Azimio la Umoja One Kenya presidential candidate Raila Odinga and his running mate Martha Karua. In a summarized ruling read by Chief Justice Martha Koome, the judges affirmed that President-elect William Ruto garnered 50+1% of the vote as stipulated by the Constitution for a presidential election win and was duly elected in accordance with the Constitution. The judges, further ruled that although a number of irregularities and illegalities were witnessed in the presidential elections just conducted by the IEBC, they had no effect at all on the final result of the presidential poll. Ben Chumba takes us through the judgment by the Supreme Court.
As a consequence, we declare the election of the first respondent as president-elect to be varied under Article 143 of the Constitution.
Blow by blow, all the 7 judges of the Supreme Court knocked out entire petition by Azimio la Umoja One Kenya presidential candidate Raila Odinga and his running mate Martha Karua. First to be dismissed were allegations that the technology deployed by IEBC failed to meet the standards of integrity, verifiability, transparency to guarantee credibility of results. The Supreme Court judges finding no evidence to support the allegations.
No credible evidence meeting the requisite standard of proof of access to the system by unauthorized persons was adduced by the petitioners. The scrutiny report prepared by the registrar of this court did not reveal any security breaches of the IEBC's RTS.
On whether there was interference of Forms 34A from the polling station to the IEBC portal, the Apex Court ruled that the petitioners failed to provide credible evidence to justify allegations that 11,000 Forms 34A were staged and modified by unknown individuals.
In our considered view, there was no evidence of a man in the middle server configured to the IEBC's VPN network, and no evidence was produced to show that the chairperson of IEBC and staff were part of the arranged conspiracy to stage the transmission process.
In determining whether there were differences between Form 34A on the portal, Form 34A at the tallying center, and Form 34A with the agents at the polling station, the judges were not convinced by affidavit sworn by John Githongo, equally dismissing it.
Those averments contain no more than incredible and hearsay evidence. No admissible evidence was presented to prove the allegation that Forms 34A were fraudulently altered by a group situated in Karen under the direction of persons named in the affidavit.
Lawyer Julie Soweto's presentation at the Supreme Court on claims of foreign footprints on Forms 34A uploaded in the IEBC portal bearing the name of one Jose Camargo, however, did not convince the judges.
This also turned out to be no more than hot air, and we were taken on a wild goose chase that yielded nothing of probative value.
The fourth issue of determination was whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kacheliba, Rongai and Pokot South constituencies and electoral wards resulted in voter suppression to the detriment of the petitioners. Although the judges acknowledged voter suppression as a political strategy to influence the outcome of an election, they found no merit on the claim.
From the explanation tendered, we are satisfied that the postponement was occasioned by a genuine mistake, which in our view could have been avoided had the members and staff of IEBC been more diligent when they went to inspect the templates in Athens, Greece.
The court also found no unexplainable discrepancies between votes cast for presidential candidates and other elective positions to justify nullification of the election.
Not a single document has been presented by the first petitioner to prove systemic ballot stuffing. A figure of 33,208 votes relied on in this claim is based on unproven hypotheses.
However, Despite agreeing with the petitioners that IEBC Chairman Wafula Chebukati cannot allocate to himself the power to verify and tally the results of a presidential election to the exclusion of other members of the commission, the apex court said the dissenting 4 commissioners who poked holes on the presidential results actively participated in the verification and tallying exercise at the Bomas of Kenya.
In the absence of any evidence of violation of the Constitution and our electoral laws, how can we upset an election in which the people are participating without hindrance, as they made their political choices pursuant to Article 38 of the Constitution? To do this would be tantamount to subjecting the sovereign will of the Kenyan people to the quorum antics of IEBC. This we cannot do.
The aggregation of the percentages garnered by 4 presidential candidates and the final tabulation announced by IEBC Chairman Wafula Chebukati was also approved by the court.
Consequently, we find that the petitioners did not provide a watertight case to warrant the setting aside of the results of the presidential election on the basis of not having met the threshold provided under Article 138(4)(a) of the Constitution.
Although a number of irregularities and illegalities were witnessed in the presidential elections conducted by IEBC, the judges, however, said it had no effect on the final result of the presidential elections. The apex court promising to provide a detailed judgment in 21 days. Ben Chumba, Prime Edition.